All right, welcome everyone. This is our December Facts and Snacks presented by Violence Free Colorado. My name is Brandy. My pronouns are she, her, hers, and I work here with work at Violence Free Colorado. And I'm excited to present this awesome webinar from the staff at Rocky Mountain Victim Law Center. So we have Kazi Houston, Legal Director, Emily, who's also the Executive Director, and they are going to be presenting on protecting survivor privacy, confidentiality, and privilege. So I encourage you all to introduce yourselves in the chat and use the chat to ask questions. We will also have some polls during the presentation, and my apologies again for not being able to offer Spanish interpretation for this particular webinar. We will be working on that to make sure moving forward we have Spanish interpretation, so my apologies for that. I'm going to go ahead and send it over to Kazi and Emily. Feel free to introduce yourselves more and we'll get started.
Excellent. Thank you so much for the warm welcome, Brandy, and thank you for all who are here and joining us today. We'll do a little bit of an introduction of ourselves and who we are at the Rocky Mountain Victim Law Center. We will keep an eye on the chat. We have some polls that we're going to ask you to help us out with throughout today as well. So please use both of those features to communicate with us, and we're happy to answer questions as we go through the presentation today. To get us started, I wanted to introduce myself. I am Emily Tofte Nestaval. I am the Executive Director at the Rocky Mountain Victim Law Center. I have been working with survivors in various capacities for the past 22 years, 8 of those years at the Rocky Mountain Victim Law Center. I'm really excited to be joining you all today.
And good afternoon, everyone. My name is Kazi Houston. I'm the Legal Director at Rocky Mountain Victim Law Center. And I am thrilled to have you all join us today to talk about this topic. We get a ton of questions from community providers and survivors we work with related to privacy, confidentiality, and privilege, and are very much looking forward to talking more about this important information today.
Excellent. So we want to introduce you all a little bit to our organization. I'm seeing some folks on the line who have worked with us before, but we'll do a bit of an overview of who we are here at the Rocky Mountain Victim Law Center. So Rocky Mountain Victim Law Center is a nonprofit organization providing free legal services to crime victims across the state of Colorado. We do that primarily through 3 different programs. The program that we were founded upon is our Victim Rights Legal Services program. Through this program, we offer direct representation to victims of VRA crimes or Victims' Rights Act crimes in criminal cases to ensure their rights and their privacy are protected and maintained and fully enforced. We also have our Title IX Legal Services program, where we provide direct representation and advocacy to survivors of gender-based violence and harassment in school settings. This program is available to survivors kindergarten through higher ed. So anyone who is in an education setting that needs help to access their Title IX rights can utilize that service. And last but certainly not least, we have our Legal Information Network of Colorado, or LINK program. This program is really set up to address the civil legal issues that arise as related to victimization. We provide help and support directly to survivors' representation in cases such as name changes. Occasionally, we'll do some protection orders, housing issues that might come up, and other related legal issues that arise from victimization. We also want to make sure that victims and survivors across Colorado have access to accurate and reliable legal information. We provide that through our coloradolink.org website, which you all are encouraged to visit and look at to find out different definitions, legal processes, legal information that might be helpful to those you're providing support and services to. And through all of our programs, we provide technical assistance to other professionals in the field who might be directly working with victim survivors or may come in contact with victims and survivors. We want to make sure that you all as professionals have access to help and support or information as you need in the provision of the aftermath and support that you offer to victims and survivors. And last, certainly not least, through our link program, we also have a project called Project Attorney Connect. There are some legal issues that Rocky Mountain Victim Law Center does not work on in-house. That would include many family law issues we do not work on. But Project Attorney Connect is a group of attorneys that we work with who are trauma-informed and victim-centered. And we contract with them on a low bono basis to provide representation to survivors. RMDLC pays for the legal fees and the attorney's fees on that and connects the survivor to those services. Did I miss anything, Kazi?
I think you got it all. So diving into our content today, we wanted to talk a little bit, just starting to talk about why privacy is so important for victims and survivors. A note on language, I will just note that we often use the term victim because it is the legal term in criminal cases. But we try and use that also interchangeably with survivor because we know people have different preference on which term they like to use. So if you see us using both, that's why. What I always want to note, which all of you know because you work with victims and survivors, is that investigation and prosecution of crimes or even seeking services outside of the criminal legal system often involves very personal information and needing to share very personal information, especially when we're talking about cases and victimization involving domestic violence, sexual assault, and other interpersonal violence. And before people share information, it's always very important that they know who's going to get their information, what's going to happen to it. I think sometimes of all the forms that we get whenever you sign any contract or any email that you're on, where they're often sending things and saying, you know, this is an update on our privacy policy and who will share information. The same sort of thing applies when we think about privacy for victims and survivors, is making sure they know things, like if they're sharing information with law enforcement and prosecutors, that it will likely, thank you for the flag on the sun, we'll fix it. Information shared with law enforcement and prosecution very likely will be shared with the defense in a case. Another thing that we always want to note is that crime victims are often reluctant to share personal information for very legitimate reasons. Safety is one of the key reasons, embarrassment about what they're sharing, wanting to make sure the information is protected. And that's important to know what those reasons are, why they are reluctant to share information, what options exist to make that a safer option so that people can make informed decisions about what information they share.
Kazi, Kazi, I just want to interrupt you really quickly. So sorry. First, I just want to offer the reminder to slow down a little bit with speaking for the ASL interpretation, but also we were getting clearer sound when Emily was speaking, but I don't know if you sound a little farther away. I'm not sure if that's the sound issue that folks are experiencing.
Okay. Thanks, Brandy. We'll keep trying to adjust our different.
Well, I did not hear what you just said. I'm so sorry.
Is it any better right now?
Oh, that is a little better. Yes. Yes.
Okay. We will do that then. Okay. Sorry if there was things that were hard to hear. We will get you all caught up on the content. The last thing we want to note is just an initial comment is that following an assault or victimization, victims and survivors are often asked to repeat and disclose their story many, many times. So sometimes in considering what information to collect from people and what to tell them they need to share, it's important to consider, are there better ways to get that information so they don't have to keep repeating the same story?
And we're just juggling the computer around here just a little bit, so bear with us while we're working on sound. So next slide, what we want to talk about is that it's always important to remember that victims have choice in who their personal information is shared with. Just because someone is a victim of a certain crime doesn't mean that their whole life is now an open book, or that they don't have a right to privacy, or that, and people might talk to them as if they have to share certain things. Victims still have a right to pick and choose who they tell what to. It can be helpful in the course of an investigation for someone to share certain information, but certainly they're not required to. The Victims' Rights Act in Colorado includes protections for victim privacy in criminal cases, such as protecting someone's name, address, job location, social security number, that basically nobody can ask a victim or survivor to disclose that on the record during court proceedings as a victim of crime. One of the questions that we received prior to the webinar today was, why is anyone's address ever public knowledge? And it can come out in a couple different ways. In Colorado, people's address is tied to voter registration. And so that's often the way that people are most exposed when it comes to their personal address. There's also addresses, names and addresses are connected through purchasing a property. So things can be searched publicly on records requests around property ownership and purchasing houses. Kazi, do you have any insight as to why Colorado requires this?
I couldn't say broadly what the policy purpose is for making things accessible, but I do think that's pretty standard. It's a bigger push to make sure that there are laws in place to build in some protection of addresses and personal information when that's possible. Like through the address confidentiality program, certain public officials can keep their address private, and making sure that there's safety measures in place, because most places do generally have a starting threshold of having all of those things be public.
But to the question that was asked as well around, I think it highlights the importance of privacy and why survivors need that, because it can really serve a safety purpose as well, to have some anonymity and some protection about where one's location might be. Confidentiality is also a really big thing that we want to talk about. Certain professionals, like probably many of you here on the webinar today, have a professional or legal obligation to keep client information confidential. Funding sources such as VAWA, the Violence Against Women Act, or VOCA, the Victims of Crime Act, those both require that if you're providing direct services that are funded by either of these funding sources, that you do offer your clients some confidentiality. In Colorado, as many of us know, if you're an advocate for domestic violence or sexual assault and meet the certain number of training hours that are required, you actually can offer privilege, which is even a bit more protective than confidentiality. Additional professionals that have confidential and privileged communications would include medical and mental health professionals. And then, of course, as I just said, domestic violence and sexual assault victim advocates who are community-based can offer privileged communications. It's important to note, as probably many of you already know, that system-based advocates or victim witness coordinators cannot offer privileged communications with victims and survivors. And so we like to highlight that that victims come into contact with many, many people who may offer privilege, they may offer confidentiality, or they might not be able to offer either of these. And making sure that the folks that you're supporting understand how their information is going to be shared, when they share it with who, is really important. And we talk often about having that conversation with survivors early, often, and frequently. And so one time is often not enough. Victims and survivors are often dealing with
so many different systems, people, issues, on top of just navigating their own potential trauma that might be coming up, that the more that you can help someone sort out and understand who has privilege, who has confidentiality, and who offers neither of those, and where the information that they're sharing might end up, can help them make really good informed decisions about who and why they're sharing information.
The next term that we want to start by defining today and explaining is privilege, that Emily was just talking about. Privilege is the highest level of protection available for protecting information of victims and survivors. It is a legal term that says if there's conversations that happen with someone who has privilege, they can't be compelled or forced to share any of the information shared with them unless the person whose information it is gives them permission to share it and waives that privilege, or a court orders that it has to be shared. This really comes from a broad public policy purpose, where our state has said they think certain professions and conversations that people have are so important that that information needs to be protected, so that people can speak very freely to those kinds of service providers and professions. And you can see on here the bottom of a list of what some of those professions are: attorneys, clergy, religious figures, medical and mental health professionals, certified public accountants, qualified interpreters, and in Colorado, domestic violence and sex assault community-based victim advocates all have this additional protection that says you can't actually share someone's information unless you have their permission to do that. So it's even a higher level than privilege, than confidentiality.
It's also important to note that if you're joining us here today from another state, that domestic violence, sex assault victim advocates in Colorado under Colorado statute have privilege, that looks different in different states. So you will want to reference your own state laws around whether or not you are able to offer privilege or confidentiality.
The next two slides we show are, we're providing with permission from the Confidentiality Institute, which is an organization that is a great resource on navigating many of the tricky issues that come up related to confidentiality and privilege. And I particularly like these slides because it gives a good recap of how we define these different terms and how they're different. So we think of privacy as I get to decide who knows my information. I get to decide what I share with you. There's not a legal element to that definition. It's more making sure people know what you have to keep confidential or privileged, who you're going to share information with, how you're going to use it before they share information and make that personal decision. Confidentiality then is that organizational commitment to protecting information. And then privilege is that higher standard that says they can't actually make you share my information. It's a much higher level of protection.
And the they in this particular slide would refer to things like law enforcement, friends and family, and perhaps defense attorneys. The other folks who might be requesting this information, they can't make you share it.
And then this other recap slide, again, notes who is responsible and who kind of has the control in the situation of privacy, confidentiality, and privilege. Privacy, again, belongs to the individual. They get to decide what privacy they need to have control over as much of their life situations as possible. Professionals make a promise of confidentiality, either individually or as organizations, in order to build working relationships with people and honor their commitments to providing services. And then privilege is that legal definition. So it comes from the government, and in our state, it's the state legislature that drafts the laws. And they actually bestow and create the privilege in order to protect broader social and public policy values related to who needs to be able to disclose things freely to certain professionals.
One question we get asked about a lot is, what if I have privilege and confidentiality? What do I do? And generally, the default to that is always the highest level of protection is the one that needs to be followed. Some information might be confidential and privileged. When that happens, the rights of privilege control, which means it can only be shared with the victim client's permission. We did get a great question pre-submitted about this, about is there confidentiality and privilege when there's other MDT service providers on a multidisciplinary team that are all present having a conversation at the same time. Even if you are having a conversation with someone else who has confidentiality and privilege, it doesn't necessarily mean that conversation is confidential or privileged. So the MDT itself might have some agreements around confidentiality, but they aren't defined under the privilege statutes in Colorado, so they don't have that protection. And there is no protection specifically for any information shared in that space with anyone who doesn't have those agreements.
And I think it's important to think about this as you might have agreements in your multidisciplinary team that you're not going to talk about what was discussed in that meeting outside of that room or with other folks who aren't on a need-to-know basis. And that's really good best practice, but there's no legal protection around that. So it is a commitment and an agreement that you all make, but there's nothing that would protect that from coming out, let's say in court, for example, if someone were asked to share what was discussed in that meeting, because it's not a legal protection. Further, when we talk about confidentiality versus privilege, we often hear community-based advocates talking about how they're a confidential resource or they're offering their clients confidentiality, which is great in terms of providing informed consent about the kind of conversation that you all are having, but you're actually offering them privileged communication, which is more protected. And so there is a legal term of art and a difference that matters between the language of confidentiality and privilege. And we encourage people to use the word privilege when you're talking and sharing with your clients what kind of protections their communication will have with you. Using the word privilege is more accurate if you are able to offer privilege through your profession.
And another question that often comes up, similar to the one around multidisciplinary teams, is if two people who have privilege are having a conversation, is that a protected conversation? The short answer to that is no, because the information belongs to the client, to the victim survivor that is getting services. So they might give permission for a therapist or their attorney to talk to one another, but that's not the same thing as a conversation they're having individually with each of them. Where we as a law firm see this come up the most is in emails, where clients might copy multiple other providers into an email to someone on our team. And our practice to ensure we're protecting the privilege of that is always to remove the other people, email back the client and explain why we took them off of that. And then if there's certain conversations that need to happen between professionals, just make sure that there's written releases in place, that everyone knows what information can be shared and can make an informed decision about what information should be shared.
And if you're a community-based advocate in the state of Colorado who can offer privilege, we recommend that you follow a similar practice when it comes to additional professionals copied in on emails, that you take other folks off that email, you email the client directly, explain privilege, explain how that might be, including other people might open the door to some of the privileged information and conversations that you've all had, and just making sure that they're informed of the decisions that they're making before they proceed. As you can probably gather, one of the things that we stress the most is that knowledge is key. As an advocate or someone who's working with a victim or survivor, really thinking through what the victim or survivor that you're working with considers to be private. Have a good idea, have conversations with who you're working with to get a really good sense of what they consider to be private. Then explain what information is actually private and protected under law, because those two things might be different, as I mentioned earlier, depending on who they're sharing information with. Discuss with the survivor upfront, frequently and often, as I said before. And then a practical tip, as an advocate myself, one of the things that I'm frequently asking folks is, what is this other organization or individual's practice around confidentiality? Do you have privilege? What does that look like? And I always make sure to share that directly with the victim survivor that I might be working with, because I'm not going to rely on other organizations to do that for me. So, for example, as a law firm, we are not mandatory reporters. However, we frequently refer survivors to community-based domestic violence and sexual assault resource centers to get additional services and support and case management as they're navigating the aftermath of victimization. I always share with folks that you all are mandatory reporters, and what that might look like, and answer any questions they might have about it before they reach out. It is my sincerest hope that you are also disclosing what you're, under what circumstances you might be required to break privilege. However, it is just a good practical tip to share that upfront when you're providing referrals to survivors. All right, so we are, and I see that Brandy put in the chat for anyone who hasn't seen it, that today's webinar will go to 1:30. We have lots of time for questions built into this webinar. Feel free to stick them into the chat as we're going through the presentation today. We'll keep a close eye on that. We're happy to answer things in real time. We are also, you can hold your questions to the end, and we're happy to answer at the end as well. So I'm going to launch a poll, and I would love for you all to weigh in and share with us. We'll leave it open for just a few minutes. But the question is, have you ever used or created your own release of information or waiver form? Sometimes releases of information are called ROIs for short. And so we'll give you a few minutes to click in, weigh in. We see about 30% of you or so have responded. We'd love to get at least half of you telling us what your current practice is, and what your familiarity is. So excellent. We're seeing quite a few responses. Thanks for weighing in. Again, the question is, have you ever used or created your own release of information or waiver form? And we'll talk about those in detail shortly. All right, it looks like we have most of you responding. Let me share the results briefly here on the screen. It looks like we have about 38% of folks saying, yes, I've used a release of information only. Nobody has used just a waiver. Some folks have used both releases of information and waivers, and other folks are saying no, haven't used either. And I am pleased to see that no one is asking what exactly is a ROI or waiver. It sounds like you all might be familiar with them, but we're going to talk about both of them and what those are and how you can most effectively use those in your advocacy. So thank you for participating and responding to that. So releases of information here include things like informed consent. That really means that the person who's about to sign it is in a position and has the ability to actually understand what they're signing onto, that they understand what's happening with that information, that they're in a space to really absorb where that information is going to go, that it's time limited. And we'll talk about how time limited it will be, but there is a very specific end date. That the issue is specific. So we sometimes see waivers or releases of information where it just says, you can talk to the district attorney about my case. That is not issue specific. That is very, very broad and actually is not protective of all the information that you likely want to protect for the person you're working with. So what would be a better release of information around issue specific is you can talk to the prosecutor about the preliminary hearing and my role in it. That would be very issue specific. And then the releases of information must include a clear way to rescind that. So that a survivor has that choice to say, at one point, I wanted you to share this. I now do not want you to share this anymore, and I want to cancel or stop this release of information. One of your roles as you're working with someone on a release of information is to think about both what information is being shared, with whom, how you're allowed to share it, and when and for how long you are allowed to share it. So again, that time limited piece, when I was the director of an advocacy program, I often would tell our advocates, you shouldn't need to have a release for more time than 2 to 3 weeks on the issue. Now, the advocates that worked with me and for me would often complain that that's a very short window of time, that it's very hard to get anything done, that it's would be much easier just to have it signed for a year because we know that the case or the issue or the thing that we're being released to talk about is going to require multiple conversations. However, we all know also that trauma can impact someone's ability to understand where information is going and how they're interacting with different systems. And so the best thing to do that is a trauma-informed practice is to make sure that you're always having these conversations, that you're checking back in and re-signing these, making sure that everyone's on the same page and that we still want this information to be released over time. Because we know survivors change their minds because things change in their life circumstances. And that therefore is going to influence and inform your practice and what they do or do not want you to do. So as I said, make that window very time limited, very short windows, even if you think you might have to sign another one later. And then issue specific, we talked about that. Kazi, do you have any other additions you want to add?
There was some great questions that were submitted that fit well in this conversation, but I wanted to talk a little bit more too about the how information is shared and being sure that's included. If you see most releases and waivers, they list the who is sharing information. They have that way to revoke and rescind it. They might have a time limit on how long it should last. They should, what exactly is included, but often have checkboxes of can this be shared by phone? Can this be shared in an email? And what happens to this information? Is it sharing documents or is it a conversation? And making sure those things are reflected. Frequently, good releases also have a disclaimer that explains once records are shared with someone, there's not necessarily any protections about what happens after they leave the first place they belong to. So if your organization has a release to send records to, for example, human services in a child protection case, which was some of the questions we got from some of you, it is then up to them what they do with the records. Once they're shared, they're just really kind of out there. So that's part of the informed consent, is making sure people know what is going to happen to their information. Going specifically to some of these questions, it was asked, what is the best practice to share information when there is a human services case? Or can you provide proof of counseling for child protection or other court proceedings? And that's because I'm a lawyer. The answer is it depends. But the things to consider are, what does the release say? What does your client want shared? Are there things that can still be protected by privilege? Can you do a very narrow release just to share maybe a letter that confirms someone received services
or someone is getting therapy proceedings without providing any information like a diagnosis or what kind of services specifically are provided. And those are all things that should be talked through before a release is signed of what information do people want shared? What is the minimum of information you can share in order to meet their own goals? And then really base that information sharing and that release on the goals of that client.
All right, so we're going to launch into another poll. Your feedback is very helpful. So as I launch this, I'm going to read the poll to you.
So we're going to shift gears a little bit and talk about subpoenas. So a release and a waiver is much more focused on when a client wants you to share information, what do you need to do? A subpoena is more focused on when other people are asking you for information. So this poll says, have you ever received a subpoena, either to provide testimony or to turn over documentation or records for a case? So we look forward to seeing your answers on yes, to testify, yes, to turn over documents or records, yes, I've gotten a subpoena for both, no, I haven't gotten a subpoena, or the very legitimate question, what is a subpoena? And we will wait to see, we're getting quick responses from you all on this one. So definitely chime in on your experience with subpoenas.
Excellent. It looks like most folks have answered. So let me turn around and share some of our results here.
So most of you have not ever gotten a subpoena. Those of you that have are probably now feeling very jealous that they haven't had to go through that. It can be very stressful to get a subpoena. But 71% of you have never gotten a subpoena. About 14% have had a subpoena to testify, a much smaller number for records, which is where we get a lot of questions around subpoenas for records specifically. And then, like I said, very good question of what is a subpoena? Okay, so we're going to start with that question of what is a subpoena? A subpoena is a document issued in a case that is asking someone, could be anyone, a witness, a service provider, to either testify in that case and show up in court and speak and provide information that way, or to produce records or documents. That is sometimes referred to as a subpoena ducis tecum or an SDT, which is why we have SDT up here. It's Latin. And that is often more what organizations are receiving, is a subpoena for their records or documents, and then sometimes to testify. I always want to start by framing for service providers that a subpoena initially is just a request. It's a request to show up and testify. It's a request to produce records and documents. And while you have to respond to the request in some way, there is usually a way to challenge it. If you have confidentiality, if you have privilege, if you are not the right person to be getting that subpoena or who has the information that's being requested, it's really ultimately up to the judge in every case to find out if you actually have to produce the records, if you actually have to testify. And so, like I said, you do have to respond. If you get a subpoena, there's usually a date on it, but there's usually options. And what we talk about is, making sure you reach out to someone like Rocky Mountain Victim Law Center, or if your organization has counsel, to get some information about what options are, and know that even though it looks like a fancy legal document, you have to respond, but that doesn't mean your response is giving over information.
So as Kathy started to talk about, what do you do if you receive a subpoena? Do talk to clients about it. As we talked about earlier, the clients that you've worked with, they're the ones who are in charge of where their information goes. You might be the holder of that information, but they get to decide how things get shared and when, through the release of information or a waiver. So again, reach out to your client and say, I have received this. Are you aware of it? And make them aware of it. as they might have options to object to that information being shared. You could also provide them a referral to legal resources that could object on their behalf. This is one of the things that Rocky Mountain Victim Law Center does frequently and often. We are working with victims and survivors who say that their records from a community-based organization or a therapist have been subpoenaed for a criminal procedure, and we can talk to them about what their options might be under that circumstance. If you work for an organization, inform your supervisor that this has happened. Sometimes subpoenas get served in the oddest of places when you're not prepared or ready for it. It's not always that someone is going to knock on the door of your agency and give this to you. When I was a program director, I had a former volunteer from a hotline get served during class at school for record information about a survivor that she had worked with on a hotline. She did the exact right thing. She immediately called me saying, hey, I worked on this case previously when I was a volunteer for you all. I just got served. I don't know what to do. That was absolutely textbook perfect reaction. She said, I just took it. I didn't confirm or deny that I knew who the survivor was. And then I called you. So that's the kind of information, if you have a volunteer program, which many of you probably do, in the form of a 24-hour hotline or doing crisis response, that's the kind of coaching around confidentiality and privilege you want to make sure happens. Now, that particular example that I just gave is not something that happens frequently, but it can happen. So you want to make sure that your volunteers are also prepared for how to appropriately respond in these abnormal, weird situations. And then, of course, tell your supervisor. Now, as I mentioned earlier, when you speak to your client to say, we've received a request for your information or to testify about the services that we've provided you, that survivor may have legal recourse to object to that information coming into a court proceeding. Your organization may also need legal counsel to protect the fact that you have a legal obligation to keep that information private and protected, and that obligation is to the survivor. Your organization could get in trouble if you provide that information over without the appropriate release or waiver. What you don't want to do is ask a survivor to sign a release as a result of receiving a subpoena. That would not be the right practice, because there's lots of different ways to make a subpoena go away. Now, if your client does want the information that has been requested to be shared, you want to make sure that they are informed of that decision and the possible implications. This is where providing legal advice versus legal information can get particularly tricky. So if you're not an attorney, you don't want to be advising your client of what they should or should not do, but you can provide them resources like an attorney, Rocky Mountain Victim Law Center, someone who can actually advise them about what is and is not in their best interest to address the legal issue at hand.
Now, a couple more important things around subpoenas and records. One, in telling your clients that you received a subpoena, they might already know about it. It's also important to know that sometimes victims and survivors have their own case where they're asking you to provide information, and it's their attorney that has sent the subpoena for your records. That's never something you can assume or not. That's part of that conversation. So someone might have a lawsuit related to their victimization. There might be a family law case, a protection order case, where they are requesting the information that you get the subpoena for. So making sure you are clear on what it's for, talking to your client about how they feel about it is always the first step. And then in that lens, one of the great analogies that Emily has crafted before to talk about privileged information is that it's kind of like a bank. And this is a good way to think of releases and subpoenas. if you have privilege and someone gives you their information, either through therapy or other services that you provide, that information belongs to them. You don't own the information just because they deposited it with you. So similar to a bank, if you put your money in the bank, it's your money still. It doesn't belong to the bank, and you can't move that money or send it to anyone else unless you sign something to give permission or you request that it happens. It's the same thing with privileged information. If the person whose information it belongs to, your client, hasn't said it's okay to go ahead and release this to someone, to withdraw my information and give it to a different organization, it's important to make sure you don't do that unless you have that permission or a court order that in some cases can override that.
Excellent. And then, of course, if you receive a subpoena, don't automatically turn over records. Again, we often talk about subpoenas as a request for documents or a request for testimony, but it's not a court order at the moment that you receive it. The request is that everyone needs to show up with whatever has been requested, and then the attorneys will have an argument about whether or not that information it actually gets to come in, if it's legal for it to come in. And then the judge will decide whether or not that gets to come in. So again, don't release anything until there is a court order mandating that that must happen. Now, you can't just ignore a subpoena. I think that's also very important to stress. If you receive a subpoena, you do have to do something. Doing nothing is not an option. You could be in very big trouble if you don't do anything. So don't just ignore it. Get proactive, but also don't panic, because there are many things that can be done to address that. And if you need coaching or support or just want to consult with someone as you're navigating this, it's exactly what we're here to do. Kazi's and my information will be on the last slide. You can always call or email us, and we are here to help guide you step by step through that process. And I'm seeing lots of comments in the chat box about the good analogy. I'm glad it's a good analogy. I'm glad that's helpful to you all. Feel free to use it.
The other thing that often comes up is, so what do I do? If I get the subpoena, my client has told me what they want, I've talked to my supervisor, I've gotten legal advice. Now I know I need to go to court and say, these records are privileged. What do I do now? And the privilege is kind of a magic word in the legal system. It's also something that attorneys and judges understand really well because we have privilege also. So, you know, just even showing up in court and saying, you know, I believe our records are privileged is a really important way to start. If you have no other idea about what to do, what to say in court, just going in and saying, I think this is privileged should be enough to get everyone on the same page thinking about whether or not it is. The other thing that I want to note is that this year in our legislative session, they added some really important protections to subpoenas for victim records in criminal cases. We frequently saw situations where organizations were getting a subpoena for records, medical providers, therapists, different folks, and didn't know that they might have a way to object, that they didn't just have to automatically copy and turn over their records. So there's now requirements that people put information on the subpoena that says you have the ability to challenge it, don't turn these things over, come to court. And then there's a little time built in. So if a judge says at a hearing, yes, you do have to turn over these records, you have a week, unless there's other circumstances, to get things copied, so you don't have to show up with everything ready to go, and it buys a little time for everyone and builds in a lot of important protection. The next thing we want to talk about is, so what happens if you did share information? Almost always when we train on this and we talk about subpoenas and waivers, there's some very brave person that will say, oh, but wait, one time I didn't do this the right way. And there are some ways to try and improve things and fix things after information has been shared. You can't actually take back information that's shared, but there's some ways to protect it. One of the really important things is revoking the release of information or the waiver of privilege. And all releases, as we said, should have a part on the bottom that says you can sign this to revoke the release and take it away. Even if you don't still have that release, because frequently people don't, you can always just put something in writing, an email to a service provider or a detective to say, you know, I signed a release for this and I no longer give permission for you to have this information, is also enough to revoke that. If they haven't already gotten the records or whatever is included in the release, then that stops it and they can't get anything else. If they already have gotten the records, it would stop them from getting any additional records, and it might help keep the information out of a court case down the line, because it would show the intent of the person whose information it is and that they had changed their mind about who got to have that information. Another thing that's important, that's an option for attorneys in cases and prosecutors, if someone has a criminal case, is requesting a protective order. This is different than a protection order that we talk about for safety. This is specifically an order that you can ask the court to say, someone got these records, we no longer want anyone to have these, so you have to give them back, or you have to destroy them, or it might limit who has access to records. We use these fairly often in cases involving things like victim medical records, access to data from phones, things like that, where someone wants to be sure that the defendant or perpetrator in the case doesn't actually have access to the information. So it could be an order that says the attorney can look at it, but the actual defendant can't have the information. Particularly when there's a lot of safety considerations, like in stalking cases, that can be a really important thing, just to let people know they can always ask the prosecutor if there are some options for protecting their information. We've also used this for things like past medical history that might show up in a current medical record, where it might detail things, mental health diagnoses, medications, things from someone's history that aren't related to the case. A protective order could limit what information can be included or what has to be shared with the defense in a criminal case. We also talked a little bit about the new rights under the Victim Rights Act and notice around subpoenas. There has always been a right under the Victim Rights Act for a victim to be heard by the court about a subpoena for their privileged records. So if you're working with someone and their therapist or medical provider or you have gotten a subpoena for their records, they have the right to tell the court, nope, I don't want those records to be part of the case. I don't waive privilege. Or they can have their attorney do that, or ask the prosecutor to share that on their behalf as well.
Privacy and technology. This often comes up for victims and survivors. And we know that technology, things like social media and people's phones, they're really important safety tool planning for many survivors. Sometimes social media is the way that survivors stay connected to folks that maybe their offender is trying to limit access to. It can be really, truly a lifeline. It's important to know that social media, even if you think you have it locked down to friends and family, people only in your networks, only people who have requested and have permission to follow, there's still other ways to get at that information. And so we often talk about how defense attorneys might try to go through friends and family to see what a survivor has been posting on social media. And it's important that you have conversations with the folks you're working with and incorporate that as part of the safety plan, and make sure that if there is some kind of legal case proceeding forward, that they know that information might come in through unexpected people or ways that it might come in somewhat unexpectedly. And that's certainly not to scare a victim survivor, but it is important that they know whatever they might be sharing on social media could then be turned around and used against them. Same with phone and computer access. In criminal cases, we often have law enforcement asking victims and survivors to turn over their whole phone. And calling back to the first slide that we had today about how, or one of the first slides, I suppose, is that just because someone is a victim or a survivor and there's a legal case going on, doesn't mean that their entire lives should become an open book for the entire world to know and see about. They still have a right to privacy and in some cases privilege when they're sharing certain things. And so thinking through that with the survivor, especially when law enforcement is requesting to see text messages or communications or emails between the survivor and other people who might be potential witnesses. One of the things that we see law enforcement frequently doing is doing what we call a phone dump. And this is essentially a practice where they take someone's personal phone, they plug it into a machine, and it copies the phone and all its contents. Now, law enforcement may say, I'm only trying to get at the text messages between you and your disclosure to your best friend about what happened to you. However, once they have access to all of the information contained there within, they may be and likely are required to disclose that to prosecution, who is then likely and maybe legally required to disclose that over to defense. And once that happens, there's nothing that protects that information from getting to the defendant themselves. So thinking through that process as an advocate is really important. One of the things that we often recommend is having honest conversations with law enforcement about what information do you really need in this moment? Do you actually need everything from my phone? Which likely is not true. They don't need the text messages that you were sending to the other parent about a play date on an unrelated incident. That's probably not related, but if they do a phone dump, they're going to have it. If they just want the text messages that include the initial disclosure, perhaps threats from the offender to the victim survivor, talk to law enforcement about how else they can get that information. Perhaps it's taking screenshots of the phone itself and sending it over, those types of things. Sometimes we see law enforcement take actual pictures as the survivor opens their phone. They'll take out another camera and take a picture of their phone as the survivor is scrolling through the text messages. Again, victims and survivors, they do have some control over what information they share. Cases in the criminal context especially might be less easy to prosecute if law enforcement doesn't have certain information. But again, that is a choice that a survivor should make concerning who and how much information they want disclosed to law enforcement, because once it's out there, as Kazi said, it is difficult, if not impossible, to unring that bell.
And another thing that I think is always helpful to think about when I'm working with people deciding, should they give access to their phone? Should they give access to their computer or other records or their social media? Is that it's not hiding anything. People do have that right to have some privacy. Just because someone has been a victim of a crime, as Emily said, doesn't mean they give up their right to privacy. And sometimes it's important to share with other people the information that, if you think about the rights defendants have in criminal cases about protecting that information, there's no reason that should be any different. For example, there's a United States Supreme Court case that says criminal defendants don't even have to give the password to the phone to law enforcement. They can't be forced to give their fingerprint or their password code on their phone so people can even get access to it. But there's often an expectation that victims and survivors should just cooperate and turn over everything without that same level of protection for their information. So when I'm talking to people that are saying, but I don't have anything to hide and I want to be helpful and I want to keep the case moving forward, that's one of the things I often share, is that the protections are in place for the other person in the case,
you should have the same protection, the same ability to choose what you want to share or not. It doesn't mean you're hiding anything if you don't want someone to have access to everything in your life, because we all know everything in your life is on your phone.
And organizational considerations about what confidentiality and privilege look like. Developing robust policies is really a foundation of how everyone on the team can be doing the best practice to make sure that not only are you in compliance with the laws around privilege and confidentiality, but that you all have a good, solid practice of what that looks like. One of the questions that we received was asking about whether or not, or how to keep files pertaining to therapy or session notes that may become subpoenaed. That's a great question. So in the scenario where the survivor is asking you, proactively coming to you saying, hey, I'm pursuing a civil case and I would like you to disclose that I came to X, Y, and Z number of sessions and also talk about the impact that this crime had on me. That's great. That's a really detailed request that you can work on with the survivor to get that right. I will say that one of the things around note-taking in general is always thinking about it through a victim-centered, trauma-informed focus. Think about what you are actually writing down and why you're writing it down. Is it that they just said something that was interesting in session and that you need to go process that for when your own supervision? Or is it something that is actually necessary for the therapeutic record? I know that when I was practicing and doing direct therapy with survivors, my notes that I left in the actual client notes were very simple. It was had 60-minute session, discussed safety planning, and they would be very, very minimal. I would go to supervision and have longer conversations about strategy around treatment with my supervisor that was different. I always have the lens on my therapy notes around, would I want my client to read this? How would it help or hurt the relationship that I have if my client asked to see all the things that I wrote down regarding our sessions? Those are really good trauma-informed questions to ask yourself, and to ask yourself, what is the purpose of me writing this down in this moment? Is it about me or is it about their treatment? Those are really good things to think through and to also talk about in your supervision as you're getting clinical supervision.
Another thing to consider in taking notes is making sure they're very objective. That it should say things like, if appropriate to note that, or there's a purpose for it, that the client was crying, not that they seemed sad. I worked years ago with a service provider who had to give testimony in a case and spent a lot of time being cross-examined around questions like, well, how did you know she was sad? And how did you know she was scared? And was she crying? Did she say she was sad? And that was a really important reminder of making sure the note is really clear. It's not, I think this is what they were feeling, experiencing. I think this is what was going on. But being very objective and just noting what is important to note in that record. And also being very careful of what other information is included that could be harmful down the line. One of the things that we know is very common with survivors of sexual assault is that they might seek out other relationships where they can regain some control over their autonomy and their own sexual experiences and how they perceive things in their relationships. But sometimes that shows up in therapist notes around things like client is engaging in promiscuous behavior, which can be incredibly harmful in a sex assault case when the defense gets a hold of those records, potentially. So having that lens on not just what do I need to record, what judgment am I putting on it, what do I objectively know, versus noting something like talk to client about healthy relationships. Might get you the same information, but wouldn't have the same risks if those records ever became part of the case.
Onboarding expectations. So when new employees start with your organization or you have a new volunteer class coming on to support your mission and the services that you're providing, really making confidentiality and privilege, note-taking, what to do if you receive a subpoena, all part of that conversation. I know that as a best practice, often we have folks sign the confidentiality agreement for our organization annually. That's just part of, they do it when they start with the organization and then again every year thereafter, as a reminder of what their commitment is to the organization, what confidentiality and privilege look like for victims and survivors, and then also what is victim-centered in that process. Also thinking about what your confidentiality agreement looks like. There should be a provision in there that talks about how confidentiality and privilege lasts even when you've left the organization. So if your employment or volunteer career is terminated or ends for whatever reason, that you still have agreed that there is, that you will maintain any information that you received while working with the organization, and maintain that privilege. You should have policies or at least procedures, or at least at very minimum, a good idea of what to do when people leave. If you have an employer or volunteer who is voluntarily exiting your organization, the time is up, they're moving on to new, great, different adventures in their life. We often have folks re-sign the confidentiality agreement. We do a reminder at their exit interview. Like, just want to make sure that you don't have any questions about what's happening with our privilege waiver or privilege agreement, confidentiality agreement, before you depart. This does last in perpetuity, even though you're not here. If you receive a subpoena or have any questions about this that come up in future positions, you're always welcome to call the organization back. So we have frank and open conversations with people who are voluntarily leaving our organization. Occasionally, and unfortunately, we do all probably have circumstances where folks are leaving organizations involuntarily, where they're being asked to leave or their employment is being terminated. And those situations are much harder, which is why you want a provision in your confidentiality or privilege agreement that they sign when they start, talking about what things look like even after they leave. So best practice is doing a reminder when you can, at the end of someone's time with your organization, and when you can't, knowing that it's embedded into the original agreement provides your organization and the survivors you serve with the protection they need. And then planning for possible questions that arise. We all know that in this work, there's going to be questions that come up. There are what if scenarios that we can anticipate. There are also what if scenarios that we can't anticipate and we haven't thought of. In doing this work for as long as I have, 22 years now, there's almost always a surprise around the corner, something that comes out of left field and wasn't exactly planning for, and we have to get really critical in our thinking about what is victim-centered, what are my legal obligations, but where it's possible to plan for potential scenarios, definitely do that. Speak to your peers and other colleagues at different organizations. If you haven't seen it, they likely have, or they might have, and sharing that as a resource with each other is really important. And then, of course, using Violence Free Colorado as a huge resource who probably gets a lot of technical assistance questions about privilege, confidentiality, and how to handle some of the unexpected scenarios that arise when providing services to victims and survivors.
Some of the things and questions to consider are, what would your organization do if you got a subpoena? Do you have a policy around that? Do you have a policy around how you use client information in emails or on calendar invites? So many people work remotely, or their roles have them out in the community. If people have things on their phone and a calendar invite pops up with a client's name on it, and someone happens to oversee that, to look over their shoulder and catch the eye of a name of a client, that's technically a breach of confidentiality. So is there a policy around that? Is there a policy around onboarding and exiting people, as Emily was talking about? What are the issues that might come up related to protection of confidentiality and privacy? If you are on a MDT in that multidisciplinary space, what information is shared with staff members or people participating in that about what can and can't be shared? What are clients asked about, review of their cases in that type of a setting? So thinking through some of those things, what is your day-to-day practice? What are the things that you were focused on and providing as an organization? And in each step of that process every day, thinking through what questions could be headed off with a policy or just need to have some idea of a plan of how to respond.
And sometimes mistakes do happen. And I think that is one of the harder scenarios that comes up for service professionals, is that moment where we've had a breach of privilege and now we don't know what to do with it. It's important as a victim-centered practice to have that hard conversation with the survivor you're working with. Whether that's another person accidentally gets copied on an email that wasn't supposed to be copied on an email, or you were in a meeting and a text message comes in from a client and you have their full name entered as a contact in your phone, and now the prosecutor who's sitting next to you in the MVT sees that you're definitely in communication with a survivor that they might be prosecuting a case about. Whatever the planning might be, having a plan for what that looks like. I know that if I ever have to put in client information into my phone because they're texting me for whatever reason, I actually enter that as client and simply initials. I know who that's going to be, and I delete it from my phone when that communication comes to its natural end. At some point, there is usually termination from services because someone no longer requires support or help. And that person gets deleted from my phone, but also including that in your exit agreements with staff that or staff or volunteers, that they'll be cleaning out that information if they store it on their phone, or having a policy that they can't use their personal phones for work and what that might look like. I think those are all things to think through. What is the best fit for your organization, how you're going to provide services in a way that's most protective to the folks you're serving.
And one other example I wanted to give when thinking about organizational policies is looking through your forms and your paperwork and your releases and thinking about, do I need to be asking this question? There was some very good, robust, very productive conversation several years ago around protecting Social Security information for many people. And is that required? Do we need to get that for funding purposes? Is there some reason we need to ask this question? And a whole bunch of organizations just stopped asking it because it raised a lot of questions and issues, became a barrier for people with different immigration status, and really was something that most people didn't actually need to know. We don't ask people's addresses unless we need them. We almost never need someone's mailing address. And so there's no reason for us to even have that information, both from a safety lens and just if you don't actually need the information, don't ask for it. So not only just thinking of the legal eventualities, but what is in the best interest and is most victim-centered for the folks that we all work with, and giving as little information as possible, being able to make that decision about what information they're sharing or not, only asking questions that you actually need the answer to, and then being careful about how you record and document that. And then thinking about what happens to that form. Does it go to someone else? Who gets to see it? How is it recorded? Is it kept in a safe place? All of those different things are just good things to consider when thinking about different policies.
So that wraps up all of our prepared slides for you today. Again, our contact information can be found on our website. We've hyperlinked the website there for you all. You can visit our website and find our email addresses and contact us directly if you have any questions. But we would love to know what questions have come up today for you all as we've gone through these slides and this information. If you have anything coming up, Brandy, I'm not sure if folks can unmute themselves, but definitely the chat is working. So if you have questions, we can certainly read them out of there and field them.
Thanks so much, Emily and Kazi. Yes, if you would like to ask a question, you should be able to unmute yourselves. If you have a problem with that and you would like to do that, please message me in the chat and I can unmute you if you are having a problem. Just want to say thank you so much for all this awesome information while folks are thinking of their questions. And I want to let you all know that ultimately, I will be sending out these slides with the recording links. And that will come out either this Friday or by next Monday. So just want to let you all know. And as folks are thinking about questions, I can go ahead and launch our poll. Think about questions that you have for Emily and Kazi, and I'm going to go ahead and launch the, oh, no, maybe not. I'm wondering, Emily, if you're able to launch the third poll, because it is not.
So, sorry, give me one moment, let me.
Oh, wonderful. Yes, thank you so much.
Sure.
And there are 3 poll questions here, if you all wouldn't mind. I know they look familiar. I appreciate everyone who's able to answer those month to month. They give us some great tracking feedback, and we will also send out a link if you'd like to give us any narrative feedback. If you want to give any comments about the webinar or questions, that will also be anonymous, and that will be included in the follow-up email. I'm not seeing folks have any questions in the chat or trying to unmute, but feel free. This is still an option for anyone. If you have questions you're thinking about, no questions, right or wrong, big or small, any questions are great.
We know this is an area that can be very complicated, and sometimes the questions don't come up until you're actually in that situation. So want to, again, invite you all to reach out to us at any point with questions related to privacy, confidentiality, and privilege. It is by far the biggest topic we get technical assistance requests from service providers about. So definitely reach out to us. If you have them come up, we're obviously available now, but frequently it's when something happens that people remember, oh yeah, I went to this training, and let me find those people's names. So feel free to call us as those issues arise.
Well, I'm not seeing any questions come up in the chat. Let's see. Well, we can go ahead and wrap up a few minutes early if we don't have any other questions or anything else that anyone wants to add. I would say thank you so much again, Emily and Kazi. Really appreciate you taking the time to do this extended Facts and Snacks webinar, because it's such important information. And again, we will share out the recording link and the slides that'll come out soon. And again, you can always contact Violence Free Colorado for technical assistance on things specific to community-based advocacy as well. We can be that resource that helps point you in the right direction or answer the questions depending upon what comes up. We can always support with that too. So thank you all so much for being here with us, and thank you again, Emily and Kazi.
Having us.
Thank you so much for having us. We appreciate it, and would love to stay in touch. Thank you all for the work you're doing throughout Colorado.
All right, well, I'm going to go ahead and end the webinar for folks. Stop the